So today I'm going to discuss about whether adopting anti-circumvention norms in their current form in Europe and the United States was actually an ill-grounded decision or not. The presentation is based on research I conducted for the chapter of my PhD. In my PhD, I argue in favor of the adoption of one single uniform regulatory framework for the protection of technological protection measures. So technological protection measures are self-help mechanisms, such as copy protection for DVDs or password protection for online databases or encryption of television broadcast services that restrict access to works and uses of works. So what I do in my PhD is that I look at the differences between the existing regimes in Europe and the United States and examine whether these differences are justified and desirable. In that regard, I looked into the legislative history of the relevant acts that led to the adoption of anti-circumvention norms in Europe and the United States to see how they were justified. And this is what I'm going to talk to you about today. So in Europe, we can find anti-circumvention provisions in three directives. The Software Directive, which protects CPMs applied on computer programs. The Conditional Access Directive, that protects the provision of access-restricted services. And the Information Society Directive, that protects copyright CPMs applied on copyright works other than software. On the other side of the Atlantic, we have two sections, the Communications Act, that regulate the provision of access-controlled cable services on the one hand and satellite services. And then we have the Digital Millennium Copyright Act that protects DPMs applied to copyright works, including software. So if we had to categorize them, we would have on the one hand the Conditional Access Directive and the provisions of the U.S. Communications Act, which are the norms that actually regulate and that actually protect the provision of access-controlled services. And on the other hand, we would have the Information Society Directive, the Software Directive, and the DMCA, which actually are supposed to protect the content upon which technological protection measures are applied. So for the first category, for the justifications behind the adoption of the Conditional Access Directive and the Communications Acts and the sections of the Communications Acts would be that they would preserve a model for distribution of works, and in that extent they did not offer protection for content. On the other hand, what copyright holders did was that they argued that digitization and the internet actually affected their interests, and thus they said that they resorted to the use of TPMs and asked the legislator for protection. So what happened was that gradually anti-circumvention became closely related to the protection of copyright. But maybe this shouldn't be so. And despite the different formulations of the justifications of anti-circumvention in the relevant acts, they can be categorized in three main arguments. So digitization and the internet supposedly facilitated copyright infringement. They supposedly changed the nature of reproduction for private use. And finally, they required the development of new business models for the exploitation of copyright works. One may have a dispute, however, about the novel character of the threats imposed by internet digitization, as well as the suitability of TPMs and anti-circumvention to live up to the expectations and address the issues concerned. Let's look at these arguments one by one to see whether they are valid or not, starting with the facilitation of copyright infringement. So the argument brought forward was that the ease of copying, the new models for the dissemination of copyright works, and difficulties in detection and enforcement would actually facilitate copyright infringements. Well, on the one hand, with regards to commercial to a reproduction for commercial purposes. First, this is not the first time that works were unauthorized, reproduced in a large scale, commercial scale. And secondly, detection and enforcement was not that easy also in the past, before internet and digitization. And with regards to reproduction for private purposes, well, at the time of the adoption of the norms, of the relevant norms, in many countries, it was actually reproduction for private purposes was actually permitted, of course, with a supplemental scheme for levies. In particular, the fight against piracy was part of the standard rhetoric of copyright holders when they were trying to enforce their interests. And we have examples from the 18th century, printers and authors warning about losing the prize of learning and how creativity may be hampered forever. Similar arguments were raised with regard to music publishing, with regards with music works also exported to the United States, but also re-imported later on back into England. The advancement of photolithography created concerns about the mass reproduction of sheet music. However, at the time we have one of the many very good advancement in the music industry at that time. A similar concerns was also expressed in the States with regard to the player piano, but those concerns did not stop even before the turn point, before the introduction of the internet and digitization. Photocopying was thought to affect the environment like the DDT affects wildlife, and hamper the incentives that author has to write books. Phonograms and audiovisual recordings and films were said that actually would create obstacles for the production of music. Book piracy was thought as a problem in 1980s, and all these concerns were also reflected in official documents by the Commission and also in the United States. So unauthorized reproduction on a large scale was by no means a novel threat, but maybe what the internet and digitization did was to change the character of this threat. So the argument that was presented was in contrast to the analog world. Now, the new technology would create perfect copies of works at actually no cost at all to the pirate. Well, the contradiction that this claim raises that the fact is that if reproduction distribution was perfected for unauthorized works, it would also be perfected for authorized works. So perfection is interesting to the extent that it makes copies interchangeable substitutes of authorized works. And a handwritten unauthorized copy of a book in the 16th century would be a substitute for the authorized work, just like a book imported from the US or the Netherlands would be a substitute of the authorized printed book in the 18th and 19th centuries. The same is true for massively produced tapes in the 70s, and just like it's true for DVDs nowadays. So what would happen is that the reduction of costs and the ease of unauthorized reproduction and dissemination would only create a greater profit margin for pirates if only three market factors remain the same. So we'd actually have three scenarios. Either copyright holders would take advantage of the reduction of costs and the perfection of copying, and thus be able to offer the works in a lower price, thus driving some pirates out of the market, or they would not take advantage of it, and so the pirates could have an extra incentive to engage into piracy. Or finally, both would have taken advantage of the technology, in which case the situation would have been more or less the same. And with regard to the fact that actually costs of reproduction were reduced for the copyright holders, we can take the example of books, of hard copy books and e-books. So copyright holders would usually say that what is happening is that the cost is high because they have to pay for royalties, and the marketing and the editing of the book expense is still the same. The expenses for these things are the same. But then, I mean, even if we say that this cost could be the 1/3 of the cost for the production of a book, which is a very a very not a very rough prediction. Then still, with regard to ebooks, we have less costs for we have no books, no returns. We have no warehouse fees. Having supporting an electronic marketplace is much less expensive than actually supporting many bookstores. Distribution is cheaper or even cost less. So there was the opportunity for copyright holders to take advantage of the technology. But even if they did not, TPMs were not the means to deter commercial pirates. So commercial organized piracy had thrived when reproduction was subject to numerous limitations, like long printing schedules, high production costs, complex distribution networks, a more limited market for the works. So it's naive to say that TPMs were going to affect them, we're going to deter them, and especially since the claim was made repeatedly that for every lock there is a key. So you would have expected that pirates would be able to find it, and even if they were not, digital reproduction is always subject to the analog hole. In addition to that, it's not only TPMs that are not able to deter pirates, but it's the fact that anti-circumvention, their legal protection, does not add that much. Because if pirates could not be deterred by the fact that that they were infringing copyright law, why would they be deterred by the fact that they were infringing another violation? And with regard to the people that were actually helping them circumvent the technological protection measures, they could still be held liable under secondary liability doctrines. So we saw that internet digitization did not create a novel threat for the interests of copyright holders, and even if it did, TPMs and anti-circumvention were not the means to address them. And they were not the means to address also the alleged negative impact on the detection of enforcement of copyright infringement. And this is so because because it's not only the pirates that could be found everywhere in the globe, but also people circumventing them. So there will be the same difficulties in detection and enforcement for circumventors of technological protection measures, as they would be for the copyright infringements. And such claims were actually also was also brought in the past. So in the analog offline environment, there were very complex distribution networks of copyright works. They would be sold in gas stations, the back of trucks, backyards. So it was very hard, and they required effective search and seizure procedures to be able to gain them. Moreover, copyright infringements were also not of strictly national nature. There were concerns about books being imported from India, Southeast Asia, and other countries, also in the 70s and the 80s, just before the introduction of the internet. And in a report, 1983 report of the music of the IFPI, it is reported that infringers do not just copy music of the songs of their own country, but whatever is popular. And on top of that, there was time-consuming administrative procedures that they were needed, which were administered by sometimes uncooperative foreign authorities. So we see that unauthorized reproduction was on a commercial scale was nothing new. And with regard to reproduction for private use, it was at the time of the adoption, it was permitted in many jurisdictions. With regard to Europe, all member states apart from Ireland, Luxembourg, and the UK actually permitted home copying. Whereas in the United States, after the adoption of the Copyright Act in 1976, there was at first a debate with regard to whether home copying actually constituted fair use. However, the court in the Sony Betamax case did recognize that private non-commercial copying for time-shifting purposes came within the fair use exception, and so did the Audio Home Recording Act, which was enacted with regard to the digital audio tape recorder that permitted non-commercial copying using digital or analog services. So why did right holders resort to the rhetoric with regard to piracy and infringement of their copyrights in order to adopt anti-circumvention? Well, one explanation could be they actually tried to hide the home coping debate that was going on in the US from the 70s, as we saw. So instead of saying that they wanted to change the status quo, they were presented as if they were trying to protect their rights with the protection of with the use of TPMs and the protection of anti-circumvention. Let's go now to the second argument that we can detect in the legislative history of the relevant acts, the fact that it was a change in the nature of not-for-profit coping with internet digitization. So what has happened in the past was that up to the middle of the 20th century, it was only in a limited number of places that unauthorized reproduction would be made. They would predominantly be made for profit, and they would be made by a limited number of people. Of course, all with some exceptions, but not significant exceptions that would affect the market for copyright works. So it wasn't until the introduction of the photocopiers that gave the right to students, office workers, people to make easy-to-use and inexpensive copies of works. And later on, the magnetic tape reproduction equipment allowed people to make copies of tapes for family and friends, or in the 80s, make copies of broadcasts in the video recorders. However, at the time, legislatory courts were reluctant to not allow private copying, because there was questions regarding the prejudicial effects that such exploitation had for copyright works. With regard to photocopying, a survey showed that it was mostly used for experts from journals, and it was used in ways that would actually substitute manual note-taking, typing, or handwriting. With regard to audiovisual copying devices, the Commission argued in the 1988 Green Paper that it issued that it's questionable whether the copies were of protected works, or whether these copies, and it also argued that to a significant extent, these copies were made of actually copies of purchased works, so there wasn't third-generation copies. In the US, the court found the Sony Betamax case that time shifting actually enlarged the TV viewing audience, so creating a new opportunity for the market. In short, with regard to photocopying and type recordings and videos, the copying was affordable, but still costly and time-consuming. Usually, copyright holders would have been remunerated for the original copy of their works. Usually, the copies were going to be circulated, the unauthorized copies, to a limited people, to a limited circle of friends and acquaintances which the copier would have. In contrast thereto, digital technology allows the perpetual reproduction of unauthorized copies without any quality deterioration. The internet and file sharing enlarge the circle of people to whom the unauthorized copies can be circulated, to people that have no other connection with each other can actually exchange unauthorized copies of works. There is no need to induce people to engage in piracy of this sort, because the copy circulator does not gain any profits in order to have an incentive to engage into that. And to that extent, the costless reproduction can actually lead to a market failure. Also, here there are greater difficulties with regard to the detection and enforcement of copyright works, to the extent that it's not a good marketing strategy to go against your consumers or your potential consumers, and it's impossible to enforce the law against everybody due to the large scale of the possible violations. And if you do, you have the run of treating some people like scapegoats, thus making you even more not wanting. So does this mean that we came to the end of an era and creativity came to an end? Well, definitely no, because copyright law has, and because technology has brought changes to the way that works were the exploitation of works, and copyright law so far has adopted to that. So although in the 20s radio was viewed as a threat to the market for records, nowadays it's used as an effective tool to promote songs and boost sales. Or with regard to the video, to the VCR, At first, it was seen as a threat, and after the whole litigation ended with the Sony Betamax decision, it was found out that it could open markets for selling and renting videotapes, market that was used in the end for DVDs. So the network digital environment constitutes a new market by itself, and this is something that has been recognized by the legislature. The possibility of internet digitization to establish new models for the exploitation of works. TPMs were thought to be able to promote and safeguard pay-per-use models of exploitation. And however, it was argued that in order for this to take place, this was dependent upon providing sufficient incentives to copyright holder to put the works into their market. Otherwise, this possibilities would have never taken into these possibilities that the new technology provided, which have never been taken into advantage. However, there is no actual need for the legislative incentives, because the exploitation of copyright works online was not a choice that copyright holders had, but it was actually the best way to promote their interests, reach more further audiences, and promote and gain more revenues. They could take advantage of the lower production dissemination costs to expand to new markets and drive the pirates out of them. So indeed, the new technology offered potential for new market players to enter the market. So cheap music could boost the sale for machines like MP3 players or the Amazon Kindle, and then with a form of bundling, the technology producers could actually help into offering music for free. Also, the wide availability of works effectively for free can raise legitimate demand through positive demand-side externalities. This means that if music is available almost for free, then this may make more people available with more different kinds of music, and then can make the performances of such artists more popular and raise the demand for more concerts. Likewise, authors of books could make more revenues by making book presentations of their work. And indeed, empirical studies have shown that the advent of technology did not discourage the production of copyright works, with regard to books at least, or also with film production. So, to conclude and not bore you any longer, TPMs and anti-circumvention regulations were presented by the legislature and by copyright holders as a means to protect them from allegedly novel threats, as a means to compensate them for the harm that they would allegedly endure, and finally as a means to encourage them to exploit the potentials offered by new technologies. In reality, though, they were nothing more than a means to promote new models for the exploitation of created works, as the traditional ways were challenged. Such models, such the ones that are used and are protected by the Conditional Access Directive in Europe and the United States, by the Communications Act. Thank you very much. And I will be very happy to hear any questions that you might have.